One of the key skills that we have as lawyers is the ability to keep track of developments in the law and to predict what future developments may occur. Now, with legislation, this is a matter of keeping track of the political context and understanding the different political decisions that will be made to change legislation in the future. The common law is quite different, and the common law is quite a strange beast, and its development occurs in a very different way. So, we're going to have a quick look at the reasons why common law is so unusual, and then look at some of the different ways in which we can think about law or conceptualise law, different ways that have been suggested by different people over time that might help us understand the way in which these changes occur. So, what is unusual about common law, especially compared to, say, legislation, where we have this process where we see need for change, change occurs, the laws are rewritten or not, according to a political process? Well, first of all, the common law only engages with legal change when a case is brought before it. The common law sits inert if there are no cases that are brought before the courts, and definitely when there are no cases that are brought on appeal. So it not only has to get through the front door of the courtroom, but it also has to be a case that goes on appeal. And there might be all sorts of reasons why it's in various people's interests not to actually appeal cases in certain circumstances, and one of those is not wanting to set new precedents. Second is the common law is the work of many hands across space and across time, and even across these days different jurisdictions as we are becoming more and more influenced by the globalised world. So whereas something like legislation is a collaborative process, this is a massive collaboration process with lots of different people, lots of different times engaging together. Leading on from that, law is never 100% a single person's work. So a lot of the things we use to discuss law, when we talk about what was the intention here, or we think about law as being designed in a particular way, it simply isn't true. We use those sorts of terms as easy placeholders, but it is impossible to say what the intention is in the development of, say, the law of negligence over time. Different people have had different intentions for shaping it across time, but it's a big collaborative work, and unlike a film where you might be able to say the director has the master intention as to what everyone does in that collaborative process, this is a situation where it is a truly collaborative process with lots of different people having lots of different intentions along the way. Law also uses analogous reasoning, and because of that, patterns become very, very important. It becomes very, very important if this is a similar fact circumstance, or there's a similar situation where a similar legal principle is involved. And because of the human tendency to look for patterns and to look for order out of chaos, we've developed this concept of legal principles. And legal principles may be stated as a matter of intention, but often where they occur is when we take a step back and we look at the law's development. We say, well, obviously what makes sense of all of these is a legal principle that is in common across them. And finally, law overtly uses metaphor and symbols, draws on ideal concepts such as justice and equality, and deliberately has this poetic element to it, which it doesn't seem very obvious at first. When we read a case, we don't look at it and say, well, this is poetry. But law is by its very nature something that engages with non-concrete issues. It deals with big issues such as justice, big ideals, and it is not something that's simply a matter of ratcheting through the facts and making a determination in the same way that a computer might. So there's been all different metaphors that have been used throughout time to describe what law is. And one of the oldest ones is the idea of law as a monolith. It's a big, solid, stately, concrete exercise of power. Very phallic power, of course, and that's not a coincidence at all. And a lot of the original metaphors used to describe a legalistic approach is using this sort of solid monolithic approach. In truth, however, law operates more like a net. What we rarely get is, and one of the things, the reason why a net works is that it catches the fish, or it catches the big fish and it lets lots of other things through, such as water or the small fish that you might not want. or various other bits and pieces. And that's probably a more productive way of thinking of law, is that it has to be designed not as a big one single solid thing, but as something that is porous, and it's something that catches hopefully most of the things you want, doesn't let too many things go that you don't want caught within the regulatory network, but is able to function in a realistic way. So those are ideas, very basic ideas of thinking about what the law itself is. In terms of the common law, there have been lots of different approaches, and of course the common law is quite idiosyncratic and is unique to the Anglo-American experience, and people in other parts of the world find the common law quite bizarre. We are more used to it, so often we don't see its bizarreness. Matthew Hale was one of the first commentators to try and describe what the common law was. And he used the metaphor of the human body, and he said, and he's using some old science here, I'm sure, but bear with me. He said the way all the cells of our body change over time, or the organs of our bodies change over time, we entirely replace all the cells of our body in 7 years, but we still seem to be the same person. We still think we're the same person. Everyone else perceives us as the same person, but none of the original parts of us are still there. Now, ignoring the 7 years thing for a moment, old science, but consider what Hale is saying, is that the common law is something that constantly changes, but it looks that it's the same because that change is so incremental. Now, Jeremy Bentham's another thinker who fiercely disputed this. He was very much in favour of codification of law in legislation. He thought that the common law was an ill-shapen heap of odds and ends, and also described the common law idea of rights as nonsense on stilts. So he's quite critical of the common law, and he actually saw it as incredibly irrational, because he wanted the simplicity and straightforwardness of legislation where you just stated what the rule was, and he failed to see what Hale saw, which was these emergent patterns and these emergent things that occurred within common law that made sense. The metaphor of the river is one that was used in the merger of the common law courts and the courts of equity. And again, I think it's quite a persuasive metaphor to think about, as all these different streams of law all joining together, and then they join together for a while and they form other tributaries, and the tributaries all pan out and form into streams, but then all the water comes back together into the one set of streams that flow into the ocean together. That's a much more poetic, I guess, idea of law. But but think about it. You think about that the law doesn't have an overall design, but it has an overall sense of order to it. And maybe another way to think about it is like a system of rivers. There was also a particularly Victorian idea of the law as a garden. The common law was a garden where there was a whole lot of different plants and a whole riot of colour and different experiences and paths, but it was all conducted according to a master plan. We had a formal garden, and we had a gardener who was in control of it all. It does beg the question as to who the gardener is, and maybe in this example we're encouraged to see the judges as a group of gardeners all busily toiling away in the garden. This approach also comes at the time where legal hermeneutics were in vogue, and these came from divinity studies, where people were trained in analysing the Bible and looking at the text of the Bible as a revelation of God's will, then went on to study law and saw law in a very similar sort of way. I can see the appeal, and it's obviously a nice, comforting view that the law is carefully tended and carefully maintained. I'm not sure that we can really sustain that. I think that rather than a garden, maybe we should look at a coral reef. One of the interesting things about coral is that all the different little pieces of coral, all the little different coral creatures, are all doing their own thing. No one is tending to the coral or explaining them what to do. And we get these magnificent shapes and forms, and unfortunately this image is of bleached coral, but you get the idea of the beautiful patterns that come not from design but from that emergent behaviour, where all the different parts of a system are following their own rules and following their own prerogatives, but together you can start seeing these patterns emerge. And the corollary of this, I think, is probably the Mandelbrot set and complexity theory and modern science of complexity theory, is it's trying to explain to us how complex systems work and how we actually get to see these emergent beautiful images, these beautiful patterns emerge out of these very simple mathematical concepts when we see them from a different point of view. And I think that's probably something that that complexity theory is an excellent way of understanding how common law change works. That we get to see emerging legal principles, we get to see these emerging patterns, but these are not necessarily things that people are deliberately conscious of as they design the pieces of the system. They're simply following the rules as they go. Anyway, this has been a variety of different images and ways to have you think about law, and I guess we get to the point of now arguing, how does this help you as a research student? So, how does all this metaphorical analysis help us as a research student? Well, first of all, I think understanding the complexity of the common law helps us understand the role of uncertainty in common law. And there's a separate video on that elsewhere in this particular set of videos, looking at the phantom zone in law. We come into law often looking for a sense of certainty and consistency. We want there to be the gardener in the garden. We want to see that it's all part of a logical and consistent design. And I think it helps us to understand that there is no gardener, but that isn't a bad thing. That the system works and evolves in the way it does and complements statutory law because it evolves in a different set of principles and evolves in response to the deliberate, hopefully rational, deliberate process of the creation of legislation. That we actually have a different set of laws that works in concert with that concept by responding to those changes and looking at the application of those changes. This also means we avoid looking for intentionality in design, and we don't end up in arguments about, well, what is the law of privacy intended to do, or what is the rule in Bunning and Cross, what is the intention behind that? Because a lot of these things are things that we're never going to know, because they're impossible to know, because these are the creations of a group of craftspeople who come together to put all their work together. And while an individual judge may say, well, my intention is to do this, that's hardly determinative. And at the end of the day, we have the words of the law to go on. We can't go to extrajudicial material to explore what they really meant when they said something or other. So we don't need to worry about intentional design. We need to worry about what the law does, and we don't even really need to consider those issues. It is not so much the death of the author, but the death of the authority in many ways. If you're a fan of post-structural fiction, which I'm sure you all are. All right. The other thing that's important for us is that what's important is looking for patterns. When we're looking for legal principles, we're not even necessarily looking for designed principles. We're not necessarily looking for a situation where a judge says, you know what, I've got a great idea. I'm going to invent this principle and this will explain the law. We're looking for the way in which those principles emerge and the way in which changes in society and changes in the world around us, pushed into the pressure of the legal framework, start creating new principles. And we see things with the emergence of equitable principles. We see the way in which some equitable principles expanded out into other areas of law because they're useful, and because the cross-pollination effect of different areas of law working together create new ideas and emerge these overall principles begin to emerge. So our human brains work on pattern recognition. We see faces in the clouds. We see faces in the rock formations on the Cydonia Plateau when they're not there. And it's a similar thing with law. And that doesn't mean that the principles we see in law aren't there. They are there, but they're not necessarily things that are created by someone to be placed there. They're things that emerge out of the way the system functions in itself. And finally, I think one impact of these different ways of thinking about the law is to consider that law is always in flux. The common law is always in flux. And as lawyers, we are actively involved in construing the law. We don't just measure it, we don't just observe it, we are participants in that system. And by being participants in that system, we are actually creating and evolving the law ourselves. And I think that's a good thing to think about.